morning, Ms. Sibison. Good morning.
Good morning, Your Honor. Madam Chief Justice, and may it please the Court, I'm Wendy Sibison. I represent Joanne Sliech-Brodeur, convicted of the first-degree murder in the killing of her husband. The jury's conclusion that my client was sane beyond a reasonable doubt is the unconstitutional product of compelled self-incrimination. In 2006, this Court addressed a case called Commonwealth versus Durham that concerned the reciprocal discovery under Rule 14. And the dissenting justices in this case were pretty sharp in their criticism of that decision, that this new rule was going to impact very severely a defendant's right to cross-examination. This case is a similar problem, where the reciprocal discovery allowed the prosecution to invade the defense camp and violate my client's constitutional rights to not produce evidence against herself.
Okay, I have a couple of questions on that issue. The Commonwealth at one point moved to compel the defendant to produce a synopsis.
Hold on one second. Do
you need your papers?
Do you want to get yourself organized again?
No, thank you.
You sure?
I'm fine.
Okay.
I didn't need it anyhow.
She knows it all. The Commonwealth moved to compel the defendant to produce a synopsis of Dr. Brown's conclusions. Had Dr. Brown reduced his conclusions to a synopsis?
At the time that this discovery order was entered, no, Your Honor.
Okay.
In fact, the defense had absolutely nothing. I think they had a name. I think they knew Dr. Kelly was going to be the expert.
I just have a question. The defense puts in the lack of criminal responsibility, makes that claim.
Yes.
If the defendant then puts her mental condition into play as a reason for the lack of criminal responsibility, has she waived any rights or privileges that she has?
I actually do need one of the cases that I just dropped on the
Okay.
floor.
Well, please pick it up.
Commonwealth versus Callahan for the first time, and this Court repeatedly held over and over again that the waiver in Blaisdell is a limited waiver.
Blaisdell applies to a court-ordered examination. This wasn't a court-ordered examination, was it? Was this a court-ordered examination?
But yes, for Dr. Kelly.
Oh,
This was
yes.
court-ordered, so this
Oh,
was
yes, ma'am.
exactly the same under Section 15.
Everything sort of started off the
Okay.
way Rule 14 contemplates.
Okay.
We filed a piece of paper saying we're going to interpose this defense, and our expert may rely in part on testimonial statements.
Right.
That's just how it got started. And then
Okay.
there was an order that the Commonwealth would pick their expert, and they did that. But then what followed was the Commonwealth sought this extraordinary discovery, and after a number of battles, the single justice cut it back a little bit, saying turn all this, actually literally about a ream of information, including masses of testimonial statements my client made to our expert, to the prosecution expert. So that's what happened next. That was 3 weeks before trial.
Okay, and at that time, did the Commonwealth have the right, in your view, to any discovery about Dr. Brown? I mean, they got a lot, but did they have the right at that point?
I think under the
anything?
rule, maybe at that point, they have the right to his CV. And there's a couple of other things, his name and address, and there's some basic just identification stuff that it did have. Yes, Your Honor.
Put aside the ream of stuff. Both the pretrial conference report, I think, referenced reports in this context, right? And that is on the issue of criminal responsibility, that there would be an exchange.
How that actually, there was a pretrial conference report. I don't think, I think maybe there was some misunderstanding, or else, I can't say what happened since I wasn't there, but this was not a report that was provided. Dr. Brown did provide a report eventually. There was no problem with providing the report. But it wasn't a report that was, the battle wasn't over his providing a report. The battle was over providing all the underlying testimonial statements that went into forming his opinion.
But I got the impression, and this is, correct me, because I
Yes.
think you will. I mean, I got the impression that part of the reason of the Commonwealth in seeking what it sought was that it was getting, it had gotten and was getting absolutely nothing from Dr. Brown as to what his diagnosis was.
They're not entitled to that. until, now let me think this through. Discovery of this sort of defense under Wardius proceeds as follows. The Commonwealth, the defense gives its notice of a defense, provides the name and address and identifying data of who their expert's going to be. Then the Commonwealth's discovery has to provide all their discovery. And then the defense provides its discovery, which would include a report. That's how Wardius says it's supposed to proceed. I have to say, I don't
When you
think
say it includes a report,
Yes.
what does the report include?
the report needs to simply, doesn't need to include any testimonial statements. In fact, it's not to include any testimonial statements. Diagnosis and a basis for opinion, but you can say basis of my opinion were certain testimonial statements. And I don't think there's really a problem. I guess there isn't a problem if, at best, if the defense is going to name certain testimonial statements, identify certain testimonial statements during the expert's testimony. I relied on these testimonial statements. Perhaps pretrial discovery should include that too, but not until after the Commonwealth's discovery of everything of the results of their expert's report. I believe that's the order it's supposed to go in. I don't want to overemphasize, I don't want to, the order in this case, because the real Wardius violation here is not the order in which things proceeded, but the grotesquely imbalanced evidence that was produced through reciprocal discovery.
But
Getting back to the ream.
But isn't that the imbalanced evidence that's produced, isn't that best dealt with by a motion to compel further responses, or a motion to strike the expert, or a motion to strike his testimony on certain subjects?
Well,
That's what they did.
There was a motion to compel. In the first place, the report
Right.
he provided, the judge himself found, of the report Dr. Kelly provided, said
Was
this doesn't even
insufficient.
say what diagnoses you did make of this person. All you
That
say
was
is
after,
she's not...
that was after the whole.
That was after all our discovery. That came, like the fifth day of trial is when we first got something from him. The judge said this isn't enough. So he provided another. But, I'm forgetting what the question was.
Let me ask another one then.
Oh, dear. It was a good
No,
question.
no, it was your statement that, you know,
Oh,
what was
Wardius.
what was included in the report?
Yes.
I know. You asked, what about a motion to compel? Well, we certainly did move to compel, and we moved to that he should provide all of his notes. And the judge said, that's fair. What did he provide? I've given it to your honors. It is a document included in the motion to expand the record. And this is what it looks like. This is the first page. And that's the second page. That was our motion to compel. That's what we got. He didn't take any notes on my client's account of the critical events. He took not one note, and I've given your honors our own division of forensic mental health that says there should be an extensive notes taken by all examining psychiatrists of the defendant's account of the events. You have these regs. I gave them to you. So that's what we got, and that's what they got. And that's why I'm not emphasizing the order, although the order is there for a good reason. It's the upshot. We got nothing. They got everything. But what they got was unconstitutional. They are not allowed to get.
Do you consider that your client's statements to the doctor were a confession of the crime?
Your honors have all of the notes that were turned over. They are sealed. The prosecutor has not seen them. She was told about them verbally by Dr. Kelly. The answer is yes.
So
The answer is yes.
So your view
Yeah,
is
yes,
the
as
Commonwealth...
best as they are certainly, to the extent she was able to remember anything, they are close.
So the substance of your view, as I understand it, maybe I'm wrong, is that the Commonwealth was never entitled to this stuff, never
right.
entitled to know what she told Dr. Brown outside of what Dr. Brown may have referenced in his report.
Yes.
Or presumably may testify to.
At best, at most, what he was going to testify to. Correct.
But so never really, even after Dr. Brown testified, the Commonwealth would not be entitled to find out what the
Correct.
defendant told Dr. Brown.
Absolutely not.
But I assume when Dr. Brown's testifying, of course, the Commonwealth can ask him extensively what the defendant told him and whether or not that was whether his opinion was based on what she told him.
I don't think that's correct, Your Honor.
You can't cross-examine the basis of the
You
expert
find out,
opinion?
discover during testimony. What else did she tell you?
Yes.
Tell me the whole story that she told you? I don't think so. No.
But you have put the mental condition of your client at issue. The doctor is testifying based on his, well, in this case, there was other thing. I mean, there was also some psychological examination, testing, but conversations. I don't see why what she told the doctor isn't.
Fair game for cross-examination at trial. The way this process was set up through... Yes.
Okay, but maybe, I mean, I'm not saying, but maybe it was set up in a nonsensical way, because how is the Commonwealth supposed to rebut
I'll tell you
an
how.
expert testimony? It can't hear it for the first time at trial and then call its expert that immediately thereafter in rebuttal.
The reason, there are two main reasons to talk about why Blaisdell was decided the way it was. In the first place, someone needs to be able to prepare a defense and talk to their expert and prepare for trial without waiving their rights to all of their rights. And one of the reasons why, I think I want to get to the way you're questioning me, that if you tell the Commonwealth every single thing that the defendant told her own expert, why not her own lawyer?
Well, no.
That's something
Well, her own expert. Then what it does, if they're able to use all that information, this court has said.
No, not use it against her in substance, but
It
use it
allows
against
it-
her on the claim of lack of criminal responsibility.
If it is a complete, it is this waiver, I'm only saying what this court has said so far, is not to be held as a complete relinquishment of her privileges, because that would allow pressure on the defendant to take the witness stand herself. So you think that through. I mean, I've read that many times, and I've thought about it. What it means is the defendant gets to choose. And I just don't know quite the answer to Justice Cordy's question. Maybe the answer is you can ask and say, well, did she tell you? What else did she tell you? Maybe. But if that's allowed, what happens is the defendant chooses to have an expert testify. She doesn't choose to testify in her own defense. She chooses to have an expert testify. And he bases his opinion on certain things that she tells him. And the rest he doesn't base his opinion on. He chooses. In fact, she could choose, in this case, if she had known that every single thing she was going to tell her expert was going to be disclosed to the Commonwealth, she may have chosen not to use an expert at all, or at least to use an expert who only looked at her medical records, who looked at the police reports, and didn't interview her at all.
Well, isn't that a kind of strategic decision that counsel makes in consultation with the doctor? Do you need to interview her and get her version in order to form an opinion?
Well, yes, but the other critical part of that strategic decision is Blaisdell in Rule 14. Mm-hmm. Understanding what's waived and what isn't. And until this trial...
Why isn't the Fifth Amendment privilege waived in this kind of situation?
Because this court has repeatedly said the Commonwealth's opportunity to rebut the defendant's evidence is in forcing the defendant to submit to an extensive interview by someone in the defense camp, which this court said...
Someone in the defense camp, you mean in the prosecution camp?
No, in the defense camp.
No.
I'm sorry. No, in the prosecution camp.
Right, that's
I
what I
misspoke.
mean,
Thank
yeah.
you. Just say that
again.
is the balancing...
It's by an independent examiner.
Well, yes, except for that's not really
well,
what
no,
happened.
But the point is the Commonwealth gets to have
The same
the person
opportunity.
examined by somebody else.
It's the opportunity to
examine
develop
to examine the defendant.
Yes, it's the opportunity to develop the self-same evidence, the opportunity to elicit the self-same statements. And if the defendant doesn't submit, doesn't cooperate, there are sanctions. So that's their opportunity.
Okay,
But how can the Commonwealth be expected to rebut what the defense expert says without knowing ahead of time? I mean, all expert testimony, you can't deal with it on the spot in the middle of a trial.
Well, this is not an ordinary expert. This is an expert who's talking about criminal responsibility.
But she put into play her criminal responsibility.
Well, if this court is prepared to rethink Blaisdell after my client's trial, it still isn't right to apply it to my client.
You don't want
Because
us-
as I just said to Justice Cordy, it's not the only strategic decision when you talk to the defense expert, what do you need? It's what are we going to have to give them? If she says, I was perfectly sane, I just had a couple drinks and I wanted to kill him, do we have to give that to the Commonwealth? She didn't say that. But if she did, you need to look at what the rules are. And Blaisdell said this is a limited waiver, very limited waiver. In fact, it's so limited that it doesn't even, this court said in Callahan, it has said many other times, it doesn't even waive the statutory privilege. The prosecution's witness is still not allowed. Still, even if he knows about all kinds of admissions and confessions, he is still not allowed to testify under it because Blaisdell preserved the statutory privilege. So this is a limited waiver. This is how this court thought it through. If it's going to change it, which I think would be terrible because it involves the same kind of invasion of the defense camp as the Durham case did in requiring turning over cross-examination material of Commonwealth witnesses. This is the flip side of it, where suddenly the Commonwealth is entitled to a panoply of statements that we don't intend to put in evidence. Confessions, admissions, all kinds of damaging stuff. And by the way, that was used in this case.
Okay, but isn't there a difference between the defense contemplating the possibility of an insanity defense, giving notice of it, preserving its rights not to pursue it, and in that case, the Commonwealth has the opportunity to question the defendant in order to prepare for a rebuttal, but that information is not made available to the prosecution until the defense goes beyond contemplating an insanity defense to actually presenting it. And you presented an insanity defense here, so doesn't that put us in a different posture when you go ahead and put the defendant's mental state in issue by claiming insanity?
If I understood your question, Your Honor, actually the Commonwealth has the immediate opportunity to develop the exact same evidence.
Right, I understand.
As soon as we give notice.
But if you had given notice, Dr. Kelly interviews your client, according to Judge Spina's order, he couldn't give the admissions that were made to him to the prosecutor.
That's true.
Okay, so prosecution can't use whatever was said to Dr. Kelly until you go to trial and say, I plan to not merely contemplate insanity defense, I plan to present it. Correct? And then once you plan to present it, then that frees Dr. Kelly to testify to what your client told him. Correct?
That's not my understanding of the law, no.
So you say so that Dr. Kelly, when he testifies,
He
can't
can
make
say,
reference?
I interviewed her. He is not, as my understanding is, he is not allowed to testify to admissions and confessions that she made to him.
And
He's allowed to
anyway,
base his opinion on them, but not to testify to them.
Even on Justice
Because
Gantz's,
this court has
even
said,
on Justice Gantz's theory, though,
Yes.
on his hypothesis, how can the Commonwealth question its expert if the Commonwealth doesn't know what he's going to say? You can't put the expert up there and
well-
start asking questions and not knowing what the answers are going to be.
the Commonwealth does, well, in the first place, the Commonwealth isn't entitled to extensive, they know what he's going to say. They're getting his report.
But I
And,
think it-
and
I-
if they want to know what specific testimonial statements he's going to rely on, for example, in this case, he relied on these tests. I suppose he's allowed to give the results of the tests. But the testimonial statements that they were based on, no, not unless he's going to put them in evidence.
But who?
That's
Who?
our choice of what we
He.
get to put in
He
evidence.
who put them in evidence.
Yeah.
He who.
I beg your pardon. The basis of Dr. Brown's, of the defense expert's opinion. If he bases his opinion on specific testimonial statements.
But then when will the Commonwealth know that? I mean, we can't have a trial by ambush for either side. That
Miss,
isn't our rules.
Maybe in theory you can't have a trial by ambush, but in this case, we were the ones who were ambushed. We had no idea what Dr. Kelly based his opinion on. We had no notes. We had no testimonial statements.
Okay, but that's a different argument. I mean,
Well-
they're claiming that you were denied adequate disclosure of Dr. Kelly's statements. You're basically, the problem that I'm having at least is, under your theory of how it should play out, Dr. Brown can take 4 isolated statements of the defendant, rely upon those 4 isolated statements, give his opinion, when it turns out that there are many other statements which actually would contradict his opinion, but the prosecution will never learn of those other statements. They'll only learn of the statements which support his opinion.
It's almost,
I mean,
this
that's,
approach.
that's what you say should happen, right?
Well, I guess I almost think that there's not much difference between what this court is suggesting than just simply requiring that once she's waived the privilege, why can't the Commonwealth call her to testify? And that's one of the things this court talked about in Blaisdell. If you talk about a complete waiver in the way this court is talking about to, in theory, so-called balance the fairness of discovery, that kind of waiver would allow her to be compelled to testify. What's the difference?
Could I ask you something, stepping back
Yes,
a
and
little?
I'm in a horror that the red light is blinking.
Okay,
Complete
well, I'm going to
horror.
extend it because I get to ask a question, maybe. Here's my question, and it's, you need to educate me. If Dr. Brown testifies, you know, I think she suffers from a mental disease, all he testifies, and it's based on, she told me X, Y, and Z. You say that, so he is relying on, he has testified to statements that she made.
Yes.
You say that Dr. Kelly, when he then testifies thereafter, cannot say any statements that the defendant made to him?
I don't know. I
mean, that's how you
it's
understand
the way
our
it's-
law?
It's the way I have read the case law. That may not be so.
Okay.
Well, ordinarily, I think the rule is that you put an expert on
Yes.
in direct examination. You
Yes.
can't, other than sort of questions about what kinds of resources and things did he consult to form his opinion.
Yes.
Generally, you can't then go in on direct and outline the basis of the opinion. In
Right.
other words, to say, tell us
Well,
all
all
of the
right.
hearsay things or all of the things that you learned. That's really a subject for cross-examination.
Right. But
generally.
in this case, statements of the defendant wouldn't be exactly hearsay.
No, they wouldn't be hearsay. I guess that's right, would they?
I have a question on another subject.
But they're not admitted substantively either.
No, but
Oh.
but
No,
they're not admitted
yeah.
substantively, but they're the basis of his opinion.
Right.
Right.
But on
Mr.
direct
Vicen-
examination, I'm sorry, go ahead.
Ms. Siverson, you've obviously read Blaisdell. You may not be as familiar with Justice Quillico's dissent, in which Justice Block had joined. Now, the dissent doesn't always accurately characterize what the majority of the court is holding, but at least the dissent is highlighting what it sees as a problem. I'm not asking you to do it now, but I would appreciate it if you would take, and I would ask Ms. Montori to do the same thing, to take a look at the dissent and read your respective interpretations, taking that lens into account, because I mean, obviously the court was struggling with precisely the issue that you presented here. We're going to order that you submit to a psychiatric examination, during the course of which you're going to there's a potential that you would make inculpatory statements,
Yes.
if not confessions. And then what are we going to do about those? And I think you are raising that, albeit it came up in a discovery context. And the question is, when they wrote Blaisdell, they didn't have this kind of discovery. And maybe the answer is, you don't get it in discovery. You might be able to get it at trial, notwithstanding Justice Cowen's concerns, because it's just different when you're doing it at trial. But it would be helpful if you could look at those.
Would you like a post-argument letter
Sure.
on that, Your Honor?
Yeah.
I do want to say that this court can only go so far because there is a statute.
No,
on
no,
how far,
this takes
how
us
far
into...
the prosecution expert may go.
Yeah,
What
yeah,
statute
no,
is
no,
that?
it takes us into account.
233,
Is that 20, is that the,
20,
233,
something or
23B.
other.
And that's what Justice Quillico's talking about. Same statute.
Yes.
Same statute. I mean,
Yes.
it's all there. So you can really... So at least for me, as I was looking at this, I just found it very interesting. And I didn't want to say you should know the dissent. You don't need to. But it would be helpful because it is a very, so close to the Fifth Amendment privileges, and which both, the Commonwealth and you recognize. And just...
I have a question on a totally other subject. But,
Thank you.
That's the subject of the fact that the trial judge allowed the defendant's attorney to testify about her observations of the defendant. Now, I assume this wasn't the defendant's attorney who was representing her at
I'm sorry, I
trial.
missed that.
Okay. The judge permitted, as I understand it, the defense attorney,
Yes.
a defense attorney, to testify about her observations of the defendant and what had occurred with this, when this attorney was representing this defendant in court 2 days after the crime.
Yes.
I assume that was not the attorney who represented the defendant at trial.
Oh, no, this was actually her
Okay.
divorce attorney.
All right, well,
She
it
was
wasn't
arrested, and she just needed somebody to go to court
That wasn't
with.
completely clear to me, and the whole
That's
thing
correct.
was so strange. Okay, thank you very
Yes,
much.
I want to say one thing which is not in my brief, because I've had a crisis of conscience. On my request for 233E reduction, 33E reduction, I asked for second-degree murder. That was because I was reaching for what I thought might be realistic, but I realized it's not my job to be realistic. It's my job to ask for what I think is actually a just outcome, and I think that would be manslaughter for all the reasons that this court already has.
Thank you, Ms.
Thank you.
Sivison.
And I would also ask this court to really look at the Lanigan issue. This is absolutely critical in these cases. If psychiatry is treated as soft versus junk science, we're going to have a lot of junk science convicting defendants. And I would suggest that the respected person in this case, who has been respected many times in the past, his opinion is no longer passes the Lanigan test.
Thank you, Ms. Sivison.
Thank you.
Good morning, Ms. Montori.
Good morning. May it please the court, I'm Jane Montori, an assistant district attorney in Hampden County, appearing on behalf of the Commonwealth in this matter. This was an attempt at trial by ambush, and the procedure in this case bears that out. What the Commonwealth wanted in this case was the Dr. Brown's diagnosis of this defendant.
And where do you get your authority to get that before? Where do you get your authority to get that? Because it's you. Because 14, you talk about 14, I think A6, but it seemed to me that is that the one I mean?
Yes.
Yes. It seems to me that A6 basically cuts criminal responsibility out of this general rule.
Well, the Commonwealth reads that as saying it cuts out the Commonwealth's expert or the independent examiner. Blaisdell did not address discovery.
That's for sure. We
and
didn't
that's
have
why we're
discovery, and we might have been a lot better off. That's just my own view.
And it's not the Commonwealth's position that in pretrial discovery, the Commonwealth should get the defendant's testimonial statements that she made to her expert.
You agree you shouldn't,
We should not
but you
prior
got
to
him here.
trial.
But you did get
We
him.
did not, actually.
You should not get what before the trial?
The defendant's testimonial statements to her expert. Justice Spina ordered that what Judge Josephson had allowed the Commonwealth's motion for discovery. And I believe it's in the defendant's record appendix around page 85. Just to back up one step.
And Justice Spina forbid Dr. Kelly from giving over the defendant's statements until further order of the Superior Court,
Right.
even though the Superior Court had already ordered that.
Well,
Well, it wasn't
it's
clear,
not
but,
clear.
you know.
She ordered his curriculum vitae, either a report or correspondence, and test results. Paragraph 4, which she denied, said words to the effect of, to the extent the defendant's statements are not in the above materials, we request them, and she denied that. The material that was submitted to Dr. Kelly came from defense counsel.
But what
Okay.
what gives Dr. Kelly at that stage the right to all that information?
Just reciprocal discovery. Either the discretion or automatic.
What happens if you take, if let's assume that, I assume that Ms. Sivison is correct, and so you've got a psychiatrist like Dr. Kelly in this case, says, I'm not going to take any notes, violates all kinds of, codes of professional, regulations, and says, I just don't have anything.
But Dr. Kelly wrote a report. In fact, he wrote 2 reports
And what about all the
That was-
underlying stuff?
that were submitted to the court.
And any of the underlying material?
Well, he took 2 pages of notes.
Well, I mean, isn't this a nice
And
way
the
isn't this a nice way
defendant,
to?
believe me, cross-examined him extensively on that and
Yeah, but
used
this
it
is,
in her
but
closing.
here's my concern. If we push discovery in this direction, what's going to happen is we really will get junk science, because you're going to have lawyers saying to psychiatrists, whatever you do, don't take any notes. Don't take any notes. These are busy people. I mean, they actually see a lot of people, including a lot of patients. Sometimes they see 8 a day with very complex histories. They can say, don't take any notes, because you're going to have to turn them over. I mean, Dr. Kelly is experienced, and he's certainly experienced in the criminal justice system, and looks pretty tactical to me. And that's what we're going to end up with, which is craziness.
Well, I think if you look at the federal rule, which says that if the defendant raises a defense of lack of criminal responsibility or insanity, that what the government gets is the expert's CV, his opinion, and the basis of his opinion. And if the Commonwealth had received that in this case,
Well, and what,
none of this would have occurred.
okay, put the 2004 amendments of Rule 14 to one side for a second. So pre-September 7th, 2004, whatever day it was, what did Blaisdell say you could get and when?
Blaisdell didn't address what the Commonwealth
Does it address
could get.
report, though?
No, not of the defense expert. It only, in my reading, addresses the report of the independent examiner.
Because what Blaisdell is concerned of is the use at trial of the report and the basis of the report.
Well, I think it's
Blaisdell,
concerned with...
wasn't Blaisdell about a competency exam?
No, Blaisdell, I believe, was a criminal responsibility case. There's a later case on where the court has held that the Blaisdell procedure applies to competency.
The Blaisdell doesn't help us on the discovery. So
No, it does not.
if we can take a step back then, let me try to understand this. As a result of the various procedural orders and discovery processes, the Commonwealth got a whole bunch of material from Dr. Brown. Did the Commonwealth get it, or
no.
was it turned over to Dr.
It
Kelly?
was turned over to Dr. Kelly, and Justice Spina erected a sort of firewall and said, you cannot discuss the defendant's statements with the prosecution until by order of the Superior Court, and that's what happened here.
And that order came before Dr. Brown testified.
Yes, it came. I will say that the Commonwealth, after all of this was turned over to Dr. Kelly, there was still no report by Dr. Brown explaining what his diagnosis was. And in this case, there was not just a diagnosis of one mental disease or defect. There was a diagnosis of 4, and one of those had 2 subparts. And the prosecutor in this case, who has experience in these sorts of cases, said he was not familiar with 2 of those diagnoses. So
And that report was given to the Commonwealth before Dr. Brown testified, but during the trial.
it was the first time the Commonwealth learned his diagnosis was on the 2nd day of jury impanelment.
Now, with respect to all of the material that was turned over to Dr. Kelly, you say that was discoverable as reciprocal discovery or other discretionary discovery?
Yes, because the rule does, reciprocal discovery in the Commonwealth's view doesn't mean that the defendant has to get it first and then the Commonwealth gets it in this context.
I say usually it does.
It usually does, but in this context, because criminal responsibility is really under the control of the defendant. And although the independent examiner has an opportunity to examine the defendant is given lamb warnings. She does have a privilege against self-incrimination. So, and I think it's clear from Dr. Kelly's February 9th report, which is in the appendix of sealed documents, that the defendant was not very forthcoming in this case with him. I mean, she certainly it didn't rise to the level of deprivation of an interview, but it doesn't appear that she gave him the same thing she gave her expert. And I think that's one of the principles of Blaisdell. There's a sort of an assumption that, well, the independent examiner is going to get the same thing as the defense expert.
I'm not sure that you're correct about that.
And in this case...
I'm really not sure that you're correct about that.
Well, I think that, but that...
When you say the same thing, what do you mean the same
Well, the
thing?
same, I mean, they're given access, but the same sorts of information, so that it equals it evens out the playing field. But I think this case shows that that's not what happens.
I think a fair reading of Blaisdell is you've got two experts. Different experts will ask different questions. The expert may decide that, tell me precisely what happened that morning, right? Another expert may not care about what happened that morning. If the expert, the Commonwealth's expert, the independent expert, asks questions, tell me precisely where were you, what were you thinking, da-da-da, and she says, I can't remember, then the expert can testify at trial. I thought it was a fabrication. I thought it was malingering. I thought it was da-da-da-da-da. You know, she obviously had enough mental capacity to, I mean, that's what plays out. It's not saying what she tells this expert is going to be compared to what she tells another expert, and that the jury are then somehow going to say, well, she was lying in one and lying in the other.
But I think that's the assumption, at least part of the assumption upon which Blaisdell is based.
No, part of the assumption on which Blaisdell is based is each expert can, if they are an expert, can ascertain what information the expert needs and what information it doesn't get, and draw a conclusion from that. It doesn't go and look and see what information is given to a different psychiatrist and to say, well, I think based on what you gave to psychiatrist A and what you're giving me, I'm making a conclusion. That, it seems to me, is not what Blaisdell is all about. I mean, there is an assumption running through Blaisdell that there's a little difference between talking to your own expert initially and talking to an independent expert.
I don't agree
and the
with
reason
that.
is because there's no reciprocal discovery in Blaisdell. The thrust of Blaisdell is to a defendant, if you want to raise this defense, you are going to have to submit yourself to an independent examination. That's the focus, and what happens in that examination may lead you to make inculpatory statements, if not a confession. It had nothing to do with what was going on with the other expert.
Right.
There could be 9 other experts that the defendant had talked to.
But I think maybe I didn't make myself clear. I think Blaisdell talked about evening the playing field by giving the Commonwealth access.
But it's
the
access
same
to the
access.
defendant,
No,
not
but
to
it's-
what the defendant says to another psychiatrist or to anybody else.
It's not quite evening. I don't think you can even say it's evening the playing field in the sense that defendant picks an expert and has total access to him or her. That triggers the right to have the defendant examined by an independent expert that the Commonwealth does not have total access to. So it's not, so in a way, you know, I think there's definitely an argument that giving, well, I think it is premised on the idea that there's going to be an independent expert not connected necessarily with not connected with the Commonwealth, who's going to come to his or her own judgment based on whatever
Based
the
on
questioning
that
are.
expert's
Yes.
access. The
Right.
issue is, can we force this defendant to talk to an independent? That's the issue. Can we
That's the
force this defendant to talk to an independent expert without counsel present? Right? Because an independent expert is going to ask a whole bunch of questions which may well be inculpatory. We just had a case before, you know, somebody was trying to help himself and he didn't realize that what he was doing was confessing to felony murder. I mean, that was exactly what the Commonwealth said, and I think it's a pretty accurate one. So what the court was trying to do is to say, you're going to raise criminal responsibility. What's the Commonwealth supposed to do? They have no way of doing it. We'll tell you what we'll do. will make you talk to an independent expert. That's all you get. That's all you get. I mean, you may ask for school records or something. I don't know about that, but essentially, the core of Blaisdell is we, the state, will force you, a citizen of the state who has a powerful Fifth Amendment right and Article 12 right, not to testify. We will force you to testify if you want to raise this defense.
But we will force you to be examined.
To be examined. I mean, to talk. And that's a very unusual thing, because generally speaking, you can raise whatever defense you want to raise. You want to raise self-defense, we don't send you off to a psychiatrist and say, go tell an independent person about what happened in the self-defense. It's very unusual. And none of it had anything to do with discovery.
With respect to unusual, is this an unusual case? Is it in
Yes,
your
it is.
county?
Yes, it
is
is,
it
Your Honor.
ordinarily the case that defense experts required to give all this information to the Commonwealth's expert?
Many times they do it voluntarily. There may be redaction of statements, but in many cases it's done perhaps so that the Commonwealth will agree that the defendant was not criminally
Okay.
responsible
That's
at
one
the time.
strategic reason
and
to
then
do it, yeah.
nothing goes forward in the trial court, or
But
that
suppose
there's
it's
some
a-
sort
it's
of
a-
a plea.
But this is
suppose it's
unusual.
going to be a contested case. Criminal responsibility will be contested at trial.
It's
Then what
still
normal-
turned over in my experience,
So
Your
it's
Honor.
unusual.
This is
It
very
usually
unusual.
and that has been my experience as well. But so this
What-
Excuse me,
what's-
this-
what's the
unu-
it?
What's unusual?
What's
The fact that the Commonwealth did not get the expert's opinion and the basis of his opinion, in other words, the diagnosis.
But wait. You're missing my point. The Commonwealth, there was a whole bunch of materials. I don't know what was in it, but
I don't know
a
what was in
folio
it
of
either.
materials that Dr. Brown had, including presumably all of the statements the defendant had made to Dr. Brown. The Commonwealth was ordered to turn them over to Dr. Kelly.
No,
No, Dr. Brown
I mean, excuse me,
was ordered
to turn them over to Dr.
Kelly.
Is that unusual? I've
Yes.
never seen
Yes.
that before.
Yes.
Yes, it's very,
It's very
unusual.
unusual.
Yes.
That's the point I was trying to
Yes,
get.
because
And
And
you're
so
saying-
I'm
I'm
sorry.
sorry.
And so Dr. Kelly has this material. That's unusual. And then the court orders that Dr. Kelly can turn all of this information over to the Commonwealth
only upon
at trial.
Well, he can only. There was this protection for defendant's statements, and he could only turn over the statements upon order of the Superior Court judge.
And the
that
court
only
did order
happened-
that at trial.
That only happened after the defendant's
Opened
opening
his statement.
statement, where she made it clear that her expert would rely upon her statements.
So the prosecutor had, for cross-examining Dr. Brown, the prosecutor had all of the statements the defendant had made to Dr. Brown.
By that time, I believe he had the ones that he would have gleaned from Dr. Kelly after the Superior Court ordered him,
Okay, so Dr.
allowed
Brown...
him to speak to Dr. Kelly about defendant's statements.
All right, but I'm sorry. So, but
No,
did the
it's-
prosecutor have Dr. Brown's stuff?
Not physically, no.
Oh, so all the prosecutor got to do was talk to Dr. Kelly about what Dr. Kelly had learned from Dr. Brown's stuff.
That's correct.
But not that but the prosecutor, as I understand it, couldn't get the defendant's statements,
That's correct.
even though he could talk to Kelly about
no.
Brown, but couldn't get the statements
Until after the
the
opening
opening.
Oh, yeah,
Statement.
I'm sorry, after
Oh,
the
okay.
afternoon. I'm saying is when Dr. Brown got on the stand, the prosecutor could say, now, didn't the defendant here tell you this, and this?
Well, and actually, what happened was Dr. Brown took the stand, and the statements that the defendant now complains about were that Dr. Brown opened the door on direct examination
By doing what?
by saying that on the date of this offense, when all four of these conditions came together, that she
mental conditions?
Yeah.
Mental
Yes.
conditions, yeah.
that she suffered from there was a significant suicide attempt. He said that on direct examination. And then on cross-examination, the prosecutor ask details about that. It came out that she had gone to the bedroom with a knife and put it to her neck. But after that, she didn't remember anything. She didn't remember stabbing the victim 34 times.
So what was unusual, what was turned over in this case that was unusual?
Well, it was unusual not to have a report.
No, you said that-
I understand. I get that. I get that.
Well, it was unusual to have the materials of the defense expert go to the Commonwealth's expert. All these materials.
Okay, because
But
usually what happens?
But usually a report goes and a diagnosis.
Yes.
Right, okay. It was just that in this case they got more, but you're saying they really got less because they didn't get,
There still was no
they got
diagnosis.
papers, but they didn't get what they wanted.
Right. There was still no diagnosis. Dr. Kelly, there was an affidavit from him in the Commonwealth's appendix dated February 1st, 12 days before trial, that he had perused all of this information and still did not see a report with a diagnosis. And it wasn't until the second day of jury empanelment that the Commonwealth heard for the first time that she suffered from these 5 or 4 disorders.
Okay, and is the in ordinary cases, the report and diagnosis that are turned over don't contain statements of the defendant as to the facts of the crime?
That would
Right.
be, right, that would be considered to be privileged.
Right, okay.
And I believe, privilege, once the defendant puts her sanity in play and indicates that she's going to rely, at least in part, on her statements, then I would think that her statements could be discoverable by the Commonwealth.
When is that? You say comes into play. When?
Well, it would be probably after openings in a case like this.
There's nothing specific in Rule 14B or anywhere else that says the defendant has to supply a report from his or her expert. Is that right?
That's right. It's unlike the federal rule that mandates it.
So we're,
Did Judge Josephson say that the Commonwealth could not get the notes, or simply said you're free to give the notes, but then the Commonwealth never got them? I mean, why was it the Commonwealth didn't get the actual notes, but simply had Kelly speak to the prosecutor?
Well, because the defendant didn't comply with Judge Josephson's discovery order. She appealed to the single justice. Justice Spina denied her 211-3 petition. The Commonwealth moved to compel discovery, in other words, to compel compliance with Justice Josephson's order. Judge Sweeney allowed that motion to compel. The defendant then took another 211-3 petition, and that's when and then submitted an exemplar to Justice Spina, ex parte or in camera, that the Commonwealth didn't have access to.
Exemplar of the
And
notes?
that's when he issued his order that everything should be, that what Judge Josephson ordered should be delivered to
Right, I understand
Dr.
that. But
Kelly.
when Judge Josephson, after opening, said she's now committed to an insanity defense.
Oh, I'm sorry, it was Judge McDonald who was the trial judge.
McDonald, I'm sorry.
Yes.
When Judge McDonald said she's now committed to a insanity defense, did he say that the Commonwealth gets the notes, or simply the Commonwealth can't get the notes, but Kelly can tell the prosecutor what the notes contain?
At that point, because Justice Spina's order only precluded the Commonwealth from getting statements, I suppose prior to that, the Commonwealth could have discussed the testing materials with him. But it was only after the opening when the Commonwealth could have access to her statements through Dr. Kelly.
Right, but I'm trying to figure out why the Commonwealth didn't get the actual notes, as opposed to having Kelly tell the prosecutor what the notes contained. Was that by court order, or was that just because that's the way it played out?
I think that's the way it played out. And whether the prosecutor in this case got something other than the defendant's statements, I don't remember, and it's not clear from the record. What is clear is he still did not know what her diagnosis was. And I would just like to make one other point. Transcript volume 9 at pages 58 and 59 where Dr. Kelly explains the basis for his diagnosis that the defendant did not suffer from a mental disease or defect. He talks about reviewing her medical records, and he talks about looking at Dr. Brown's testing materials, which did not indicate any mental disease or defect. He talks about his interview with the defendant, and he talks about her writings that were close in time to the crime. So there's nothing in his opinion, either in his written reports or in his testimony, that indicates that he relied upon the defendant's statements in offering his diagnosis of her.
Ms. Montorelli, let me just, as we're thinking through this, just looking back at Blaisdell, you go to the court-appointed psychiatrist, and what the defendant has to do is be required to submit to the examination as that psychiatrist deems necessary to obtain a sufficient basis to form an opinion. So that says to me that psychiatrist can ask the defendant whatever the psychiatrist wants to ask the defendant. It's not a comparative. Then you go down, and then it's all under seal. It's all under seal. And then it is to the extent that the psychiatric report filed with the court contains privileged and non-privileged, the court may disclose the non-privileged, any non-testimonial evidence obtained from the defendant by virtue shall be admissible on behalf. I mean, it's a very careful, all the way down, sealing off that testimonial of the defendant. And then only if the defendant offers testimony based on his statements do you begin to get something different. So, it seems to me that what happened here, I can understand what may have been the triggering event, but really is not consistent with Blaisdell.
But again, Blaisdell doesn't talk about the defendant's expert and discovery of his. That's what
well,
was
what
at
I'm
issue
saying
here.
implicit in
And
well,
the Commonwealth is saying we
it can't
understand
be
that there may be privileged
yeah, but
statements
it can't
in
be
this
any
matter.
well, okay. I mean, it can't be that the Commonwealth, and you're saying so. No discovery can force the defendant to hand over, the defendant's testimonials, testimonial statements.
Prior to trial, that's right. That would be our position. And then once the door is opened at trial, then the Commonwealth could discover the testimonial statements upon which the expert relied. And there's a difference too between what the Commonwealth has access to and what can come into evidence. And it's clear from the statutes that and case law that the defendant's admissions or confessions cannot be used by their expert, even in expert testimony. But that's not what happened here. And I think the reports in this case are a good example of what could be provided, because neither report contains the defendant's statements, ultimately.
And you say the defendant's statements won't have to be turned over until it's clear they're going to rely on it at trial. Well, if the defense attorney doesn't make an opening until after the Commonwealth rests, then that could be immediately
That's the way it is.
preceding when the defense expert testifies.
Well, there might have to be some discussion then.
But that's the way. That's the way trials have been conducted for hundreds of years.
Right.
We've just made them more complicated with discovery and everything else. And
Well,
I
I
don't
would
think it's
suggest
trial
in
by
this
ambush.
case
I
that
think it's the way trials were conducted.
not getting these complicated diagnoses before cross-examination really
No, I understand the
was
diagnosis.
detrimental.
Yeah. Thank you, Ms. Montour.
Thank you very much.